In the United Methodist Church, what has happened since the Special Called General Conference in February 2019, and what does it mean as we prepare for the next regular General Conference in May 2020? Great question. There have been several developments, so in this video I provide an update regarding the traditional plan legislation, and in the next video I will go over the disaffiliation legislation and allegations of improper voting. At the Special General Conference, 17 petitions were submitted as the traditional plan. The Standing Committee on Central Conference Matters considered 2 of the petitions and did not support them. The remaining 15 petitions passed at General Conference with a few amendments. To clarify which legislation was constitutional, General Conference asked the United Methodist Judicial Council to make a final determination on the approved traditional plan legislation. At its spring 2019 meeting, the Judicial Council first considered whether the pieces of legislation in the traditional plan could stand separately, or whether to make a ruling on the entire approved plan as a unit. It decided that each petition could be enacted or nullified individually. The Judicial Council determined that 7.5 petitions were constitutional, and the remainder were unconstitutional and therefore null and void. Let's review which petitions were passed and validated. The first petition expands the definition of a self-avowed practicing homosexual to include anyone in a same-gender marriage, domestic partnership, or civil union, as well as anyone who states in a public forum that they are a practicing homosexual. The second prohibits bishops from consecrating elected Episcopal candidates if those candidates are self-avowed practicing homosexuals. In addition, if the Annual Conference Board of Ordained Ministry finds an elder or deacon candidate to be a self-avowed practicing homosexual, or if the board refuses to certify that it has carried out an examination of the candidate, then the bishop is prohibited from commissioning or ordaining that candidate. The third petition institutes mandatory minimum penalties if a clergy person is tried and found to have performed a same-gender wedding or union. The penalty for a first offense is 1 year's suspension without pay, and for a second offense is revoking the offender's clergy credentials and terminating conference membership. The fourth petition prohibits district committees on ministry and conference boards of ordained ministry from moving forward any candidate who does not pass a full examination of specific criteria in the Book of Discipline. And if the committee or board persists in advancing such a candidate, the bishop is required to rule consideration of that candidate out of order during the annual conference's clergy session. The fifth petition says that bishops can only dismiss complaints if they have no basis in law or fact, and bishops must share the reasons for dismissal with the complainant as well as with the person under complaint. The sixth petition only passed in part, and the rest was unconstitutional. The valid half says that just resolutions must name the identified harms and what actions each party will take in response. The seventh petition says that complainants must be part of the just resolution process, and every effort must be made to reach agreement with the complainant on the just resolution. The final valid petition gives the Church the right to appeal trial court decisions based on egregious errors of church law or administration. These petitions will go into effect in the U.S. jurisdictions in January 2020 and in the Central Conferences in May 2021. The Council of Bishops had further questions about the constitutionality of several parts of the traditional plan legislation, which the Judicial Council considered at its fall 2019 meeting. However, the members of the Judicial Council could not come to a majority agreement to make a ruling on the questions raised. They did indicate that they would consider specific provisions of the legislation in regard to actual cases after the legislation goes into effect. The first of those cases could go to the Judicial Council for its spring 2020 meeting. What does this mean for the United Methodist Church and for General Conference delegates? In the U.S., we can expect to see the new legislation implemented in some places and objected to in other places. There may be charges brought up under these new mandates, as well as charges for not following these mandates. Delegates to the 2020 General Conference can expect to see legislation trying to fix the constitutional issues with the petitions that were nullified, as well as legislation proposing to strike out the petitions that were enacted. Two common issues with the unconstitutional petitions were violating the constitutional guarantee of due process and raising up some parts of the Book of Discipline as more important than others. So delegates may want to evaluate the 2020 legislation for those issues, identifying any problem areas to amend or vote down. There are links to related news articles and analyses in the description below. You can also comment with your questions. In my next video, I will review what has happened with the disaffiliation legislation from the 2019 General Conference and the concern that some voters were not credentialed delegates. Subscribe to this channel to get notices about that video and other upcoming videos. Thanks for watching.